Ready? 3, 2, 1, start. It was pleaded that conduct of the parties and the attending circumstances were required to be seen, and there was no explanation why the decree holder did not deposit the balance consideration during the period interregnum, and the executive court could not enlarge the time, and there was no material to show that the sale consideration was ever offered by the company or its authorized representative, and since the relief under the Specific Relief Act was a relief based on equity, therefore the executing court had gone wrong in dismissing their application and the objections. Stop para. Initiating the arguments, the submission on behalf of the petitioners was that the decree enjoined on the plaintiff to deposit the balance sale consideration within a period of 2 months from 13/6/2011, and though they had filed an appeal but no stay was granted, and during the pendency of the first appeal the plaintiff did not approach the court nor deposited the amount. Stop. The counsel has further submitted that after the dismissal of the first appeal, they had filed the second appeal in the High Court, where stay was granted. Stop. It was urged that the plaintiff had never approached them nor offered the amount, and they had not placed on record any resolution to show that they had authorized any of its directors or any other person to take necessary steps for deposit. Stop. It was urged that the plaintiff had filed an application for deposit of the amount, and they had filed an application under section 28 of the Specific Relief Act for rescission of the agreement, as the plaintiff had not deposited the money within 2 months, but the executing court dismissed the application and allowed the plaintiff to deposit the amount. Stop. It was urged that the executing court had gone wrong holding that Article 59 of the Limitation Act was applicable, but this article is applicable to suits, and there is no time limit for filing the application under section 28 of the Act. Stop. It was urged that there was a penal clause, and since the deposit had not been made, therefore the court had no discretion left to extend the time. Stop. It was urged that in a degree passed by the court in a suit for specific performance, the court retains its control over the decree even after the decree has been passed, and this provision provides complete relief to both the parties in terms of the decree. Stop. over.